right. Welcome to the first in a series of ACICA webinars. Today's session will focus on arbitrability in the time of COVID-19. Can I ask everyone who is not presenting today to please turn on mute and turn off video, and that way we can keep the bandwidth easier and clearer for everyone to participate. We aim to make this an interactive session, and we encourage participants to send any questions to the panelists using the chat function, which can be found in the functions ribbon toward the bottom of your screens. It's the one you might find in the More Actions button. I'd like to introduce our panelists today. My name is Brenda Horrigan. I'm the president of ACICA and also a partner head of international arbitration for Australia at Herbert Smith Freehills. I have a background in a number of jurisdictions around the world. I started in the US. I then practiced in Moscow, Paris, Shanghai, and I've been here in Sydney for about the past 4 years. Next, we have Julia Dreosti, who is a principal at Lipman Corrs, which is a specialist disputes practice. She's represented clients in commercial disputes, including ad hoc and institutional arbitrations across a range of industries: energy, resources, infrastructure, construction, defense, government, financial services, and corporates. Many of her cases involve disputes in multiple jurisdictions, and her approach to these disputes is enhanced by her experiences working in Asia and Europe, her common law and civil law qualifications. Julia joined Lipman Corrs in 2014, having worked previously with major firms in Sydney, Singapore, and Paris. She's a member of the ACICA Practices and Procedures Board and the ACICA Rules Committee. Our next panelist is Joshua Paffey, who is head of arbitration at Corrs, a member of the firm's leadership team, and sits on the Diversity and Inclusion Council. He specializes in company-critical complex arbitrations, including investor-state and bilateral investment treaty disputes in Australia and overseas. Joshua is a dual Australian and British citizen and has represented clients in arbitrations in the UK, Europe, the US, the Caribbean, India, Asia Pacific, North Asia, and Australia. Joshua lectures on international commercial arbitration to university law students and is a director of ACICA. And finally, Justin Hogan-Doran is a senior barrister with 16 years experience at the Australian bar. He's regularly briefed by interstate and foreign attorneys on cross-border litigation in arbitration, infrastructure, and transport disputes. He also regularly appears in arbitrations in Australia and sits as an arbitrator in transport and construction disputes. He's a fellow of the Chartered Institute of Arbitrators and was a counselor and the treasurer of the New South Wales Bar Association in 2015. Prior to the bar, Justin worked as a banking and finance solicitor for a prominent firm and separately as a management consultant at Boston Consulting Group in Sydney and as the COO of a .com in London. So with no further ado, let's dig into the questions before the panel. Julia, maybe let's start with you. No industry sector appears to have escaped the influence of COVID-19, and commentators are anticipating a likely uptick in disputes across the board. Maybe to set the scene for today's discussion, can you talk us through how and when the issue of arbitrability will come into play in determining which of those disputes can be resolved through arbitration?
Sure. Thanks very much, Brenda. Hi, everyone. So on the issue of arbitrability, I think we can start with the general proposition that everything under the dispute sun is arbitrable. I'm not just saying that because I'm an arbitration practitioner. It's the truth. There are limited pockets and areas of law that aren't arbitrable, but the reality is, on a close analysis, that bucket is pretty small. Muscle and Boyd said all of that a lot more eloquently, but that's the general starting proposition on arbitrability. Of course, in terms of the sectors that submit disputes to arbitration, that is already very broad as well. The classic industry sectors are maritime and shipping, construction, trade and commodities. But just looking around the stats around the world, there's also a very big chunk that is in that corporate and commercial sphere, and that's obviously non-sector specific. So that gives obviously a good sense of, from the practical perspective, the range of disputes that already go through arbitration. So the question, though, of arbitrability is then whether a dispute is capable of settlement by arbitration, to use the term from the New York Convention and as given force in our domestic and international arbitration legislation. And that's capable of settlement by arbitration as opposed to needing to be determined by a court. Now, as to the when issues of arbitrability can come up, they can come up right at the start of the process and also at the end of the arbitration life cycle. So at the start, you've got questions of arbitrability that can come up in terms of a challenge to the jurisdiction of the tribunal, or equally, if one of the parties has gone off and commenced court proceedings, notwithstanding the arbitration agreement, it will come up when a party is seeking a stay of those proceedings before the court in order for that mandatory stay to be ordered. And you've also then got the question of arbitrability that can come at the end of the arbitration process, where a party may seek to set aside the award at the seat on the basis that the dispute wasn't arbitrable, or otherwise in terms of resisting recognition and enforcement at that stage. So you've got it bookending the arbitration process. And in relation to those last 2 points of the arbitration life cycle, as you'll all know, in terms of how it sits in the legislation, it also sits above the provision that the award won't be enforced because it's contrary to public policy. And there certainly is a real interplay, and often they're conflated, between those two provisions and that aspect of public policy, because inherent in this issue of arbitrability is the public interest element. So just touching briefly on that public interest element and the types of disputes that aren't amenable to arbitration, generally those are criminal proceedings, taxation, family law, IP rights to a degree. That's the bucket list that all of us often run off. You had a time there where there was also arguments about whether competition law and trust law fitted into that box as well. And increasingly, it does get smaller and smaller. And indeed, even those that are on that list have limitations. Plenty of IP disputes, for example, go to arbitration. So I think really what I wanted to end that question with was some of the guiding principles that we've seen in terms of determining arbitrability. And the first that's come through on the key cases in this area is the question of whether or not it affects third-party rights. Said in ACD Trident that this is certainly a strongly persuasive ground for non-arbitrability. The second is whether there's a sufficient element of legitimate public interest. And again, that has been construed considerably more narrowly than might appear to be the case by those words, public interest. And thirdly, and this sort of goes to that second point in terms of how narrowly it's been construed, is the point that the courts have made very, very clear, many jurisdictions, including Australia, that just because the arbitrator isn't empowered to grant all of the relief that a court is empowered to grant, for example, statutory powers, doesn't mean the dispute isn't arbitrable. And I think in the context of what I said in answer to the first part of this question, that there are really all manner of disputes that can be submitted to arbitration in terms of subject matter, and the fairly narrow approach that the courts will take in applying those tests as to what is not arbitrable. It's certainly a very broad scope indeed as to what can be resolved by arbitration.
And just to follow up on that, one of the unfortunate consequences I think everyone is expecting to come out of this crisis will be distressed companies, restructurings, and insolvencies. Those issues have historically been assumed to be non-arbitrable. Your thoughts?
Yeah, well, I mean, insolvency has certainly been one of those ones that was commonly chucked into the list of these can't go to arbitration, but actually it's a lot more nuanced in terms of what insolvency related matters are non-arbitrable, and indeed there's a real increase amongst the insolvency community as opposed to the arbitration community to look at ways in terms of restructuring and the like where arbitration might play even a more increased role. So in terms of the issues of arbitration and insolvency, historically I think some of that concern has arisen from the fact that to a degree they can be regarded as polar opposites, or polar extremes, I think was the description given in a US case, because their fundamental underpinnings are different. For an arbitration, it's all about decentralisation and party autonomy, whereas for insolvency, it's all about public centralisation and the non-fragmentation of processes. But I think a good way of looking at it is that in keeping with one of the key principles of dating, opposites attract. And I think that's right when it comes to insolvency and arbitration. Now, very much the way it's been approached in a number of jurisdictions, including in Australia, is really in terms of working out what aspects of insolvency can be submitted to arbitration, looking at this issue of drawing a distinction between core insolvency claims and non-core claims. So your non-arbitrable core claims are those claims that are really central to the winding up process that need to be before the court, either because they're in relation to powers that vest with the liquidator or concern substantive rights that are created under the insolvency legislation. And again, that third party element of if you've got other creditors that are impacted. Whereas non-core insolvency claims are more incidental to the winding up process, and these are arbitrable. And I think the key point that's emerged in terms of these cases that have in particular looked at generally an application for a winding up order to be stayed in favour of arbitration, the court has again made that point that just because the arbitral tribunal can't order the statutory relief doesn't mean the underlying dispute isn't arbitrable. And this was certainly brought to the fore as well in terms of the general comments that have been made around the Corporations Act and in ACD Tridon, where Austin in that case, in reference to the Corporations Act, said in relation to those powers, they're comparable to the powers exercised by a court under general law, and those powers under the Corporations Act aren't special powers generally that have to be exercised having regard to some sort of specialist public interest criteria, in making the point that there isn't necessarily in all aspects of the Corporations Act that public interest dimension that you need if you're going to say that that area of the law is not arbitrable. But perhaps a lot of sort of the misunderstanding for a while in this area was generated from the best floor standing case, which has often been referred to as the standing for the principle that you can't send off to arbitration these sort of winding up applications or the substance sitting underneath them. But actually, as many commentators have also observed, there's actually a closer reading of that judgment which turned very much on the facts of that case and the arbitration clause in question, which was specifically seeking in that arbitration clause to bestow on the arbitrator the power to order a winding up. And you can see why the court in that case said that was going too far. And it was, but the case itself doesn't stand for the proposition that anything associated with a winding up is not arbitrable. And obviously, as many of you would know, we've had the more recent case of WDR and Hydrox, which confirms that position. So this was dispute between the JV partners of the Masters hardware chain of stores, where in that case, the disgruntled JV partner sought a winding up order. Now, a stay was ultimately granted in that case, and it was in favour of an ACICA arbitration, so it's apt to talk about it today. And in reaching that decision, what Justice Foster made very clear is that in assessing whether or not it was appropriate to grant the stay, the fact that the winding up order was sought didn't alter the characterisation of the real controversy between the parties, and that it was appropriate for it to be a stay to be granted, and that real controversy to be resolved in the forum that had been agreed by the parties, which was to be an arbitration. So I think looking at insolvency, and yes, the reality that that is a question that is likely going to come up more so in the next few months, once we have the fallout from COVID, that certainly a lot of those disputes are arbitrable.
And maybe just one last question, and then we'll move on to the next panelist. If you had a crystal ball and we're looking 6, 9, 12 months in the future in terms of the types of disputes that we're going to be seeing, what would be in your crystal ball?
Well, I think that's right to be looking 6 or 9 months down the track in terms of what will be happening. Obviously, the Australian government, like a lot of other governments, has put a whole lot of measures in place as an economic response, both in terms of moratorium on your insolvent trading positions, an increase for statutory demands from $2,000 to $20,000, and also that period of time frame to respond to a statutory demand, which has gone up from 21 days to 6 months. So that does give this sort of window, which means we are looking 6 to 9 months down the track as to what might happen. Now, obviously, hopefully that stimulus that the government has given, certainly in some sectors, should hopefully relieve the situation for a lot of companies and help them to trade through it. But I suspect equally there are some that just won't make it on the other side, and you will inevitably have a raft of statutory demands that might be issued at that point, and also winding up applications that then follow when they're not satisfied. And again, there will be the issue in terms of stay applications being sought to the extent that that debt is disputed by one of the parties and that the parties' agreement is governed by all disputes going to arbitration. So there's certainly that dimension that can be seen down this crystal ball. I think as well, I'm being a little bit sceptical, whilst there are a lot of companies that are finding this period of time incredibly difficult, and that may devolve into more of the classic insolvency scenario. There are certainly other companies that might see this as an opportunity, and that could be opportunities either within the company itself, and there's obviously regrettably directors that may not necessarily do the right thing during this period of time when they're having that sort of breathing space. And there's certainly case law on that point in terms of companies' ability to claw back payments that a managing director has improperly siphoned off into their accounts. And that again was a case in the Victorian Supreme Court where the dispute was referred back to arbitration and a stay was granted because that was the agreement to govern that process. And that was notwithstanding all of the arguments raised by the company in that case that there were issues about potentially breach of directors' duties, that third parties like the regulators might need to know about that, and therefore it should be in the public forum. They were rejected and it was sent back out to arbitration. So there's that element with within companies. You've also got companies in terms of their external relations that to a degree now might be a good time to get out of contracts that they weren't really happy with before and to blame it on COVID. And that might be through force majeure, playing the force majeure card when not all the conditions have been satisfied, or just trying to have a bit of a power play with JV partners, which also could end up in winding up proceedings for some sort of oppression claim down the track. Then in terms of companies that don't survive or that require a significant restructure, there's obviously the element in that with restructuring still leads to a need in terms of previous claims being preserved up until those previous claims will still need to be determined, and also a question for liquidators of these companies as to whether or not they want to pursue certain claims once they're in that position. And obviously in the mix of all of this is the moratorium that comes in place once you have some of these insolvency practitioners put in place, and the decisions that come out of that, and related issues in terms of what happens to arbitrations that are in train when a company does become insolvent. But that's also just one pool of crystal ball predictions in the next 6 to 9 months. There'll also just simply be a whole lot of disputes that were going to happen anyway, that are regardless of COVID, that need to go ahead. And actually you might have companies now that across the board, even though there's a lot of cooperation between companies, there's also a lot of companies that in the good times we're happy to let cost overruns happen to a degree. We're happy for debts to be overdue for longer, that are all tightening their belts. And that may mean that suddenly actually going to arbitration, getting these disputes resolved quickly becomes much more attractive. And particularly when you've got that increase in third-party funding for commercial disputes, that too means there's a possibility that actually there will be more of those disputes in the near term, because it takes the risk of the dispute off the balance sheet, but gives the possibility of getting that money back sooner. So the long and short of it is, in the crystal ball, there will be a lot going on in 6 to 9 months.
Thanks, Julia. Joshua, maybe we can turn to you next. As Julia was discussing, there's this possibility of a perfect storm of increased disputes, but at the same time, restricted access to courts and backlogs of cases for courts to manage as we move forward with the new normal. For parties that haven't already included an arbitration clause in their underlying contracts, what can they do? And is arbitration out of the question?
Thanks, Brenda, and thanks, Julia. There's a number of points I'd like to segue from what Julia has just said. I mean, the short answer to that question, Brenda, of course, is absolutely not. Arbitration remains on the table. Again, the short answer is via submission agreements. It frequently surprises me that for a number of our sophisticated corporates out there, unlike most of the people on this call, obviously, the notion of submission agreements is not something they've turned their mind to. Many of the corporates will consider, particularly if they've not had any experience with arbitration, that the absence of an arbitration agreement means that they're generally locked into the court procedures here in Australia or indeed abroad. But I think to pick up on what Julia has said, I think we are likely to see over the next 6 months, and then potentially for a number of years yet, the shaking out of a number of disputes. Many of them are likely to require that very fast resolution to which Julia has just referred. The courts simply will not be able to deal with that. So I think it's incumbent upon a lot of our clients to be considering how they can unblock those disputes, and entering into a submission agreement is an excellent way to do it, particularly if the submission agreement is going to incorporate expedited procedures, for example. It's not always easy to do, but I think there's a number of unique aspects that the COVID situation creates for us. They're almost counterintuitive, and it touches again upon the insolvency related issues. If we have, for example, the very easy example is a supply chain blockage. In ordinary circumstances, it might be that the more dominant of the parties to that blockage or the dispute is seeking to really draw out the dispute. They're happy to submit to the courts. They're happy for it to go on for many, many years. Whereas the current situation suggests that instead of allowing a counterparty to suffer at the hands of prolonged or elongated litigation and all of the costs imposed by that, there's an opportunity to keep that counterparty afloat and to have the dispute determined very quickly. So suggesting to the party that they step out of the dispute resolution agreement that exists under the relevant transaction agreement and look at a submission agreement that contemplates a fast resolution or an expedited process is something absolutely worth looking at. And I think there's a number of particularly sophisticated clients out there, the sophisticated corporates who are looking beyond the near term, where there is a possibility for them pushing a counterparty to a dispute to the wall and into an insolvency position, to actually working with them via a submission agreement to try and keep them afloat, have something determined. And then that also adds the additional, rather counterintuitive, almost unique consideration to have. And that's what the submission agreement actually might incorporate. There might be a provision or an ability for the parties to introduce third-party funding that Julia's just referred to. There might even be an opportunity for the dominant party to carry the cost on an interim basis of an expedited process via a submission agreement. That's not something in many circumstances in corporate life that the dominant party would consider, but given the extraordinary situation that we're in globally, if it's an opportunity to maintain the solvency of a long-term supplier or a critical supplier that a corporate may want around for the near, medium, and perhaps even long term, it's something to consider. So I think submission agreements, Brenda, is something that a number of our clients ought to be considering at the moment. There's the feature that we've touched upon already too. As we come out of lockdown and the courts reopen and take on their full capacity, there's the likelihood that there will be a significant backlog of cases. So the ability in appropriate circumstances for some of those cases, instead of being determined via the courts, that they step out of the court process and via a submission agreement step into the arbitration field. That then raises a number of issues, of course, which is the very, very careful rolling over, if you like, particularly for those matters that have already commenced before the courts and in relation to which there might have been an interlocutory finding, there might have been disclosure, there might even have been an exchange of evidence, just how to capture those key features and bring them across via a submission agreement into arbitration. There's a long line of cases. There's the cases during the early 2000s before the federal court. There's even cases where Justice Kirby, when he was still at the New South Wales Supreme Court in the late 80s, commented upon not wishing to unduly restrict the rights of parties rolling out of litigation into arbitration and maintaining the decisions that have been made by those parties, but again, not unduly curtailing them moving forward in the arbitration. So certainly a lot of options for parties without arbitration agreements already on foot.
Do you have particular recommendations in terms of submission agreement drafting and the types of things you can put in or are advised not to put in?
I think it's the latter that's the most important. I think particularly given the audience to this call, who will be very much across the drafting of arbitration agreements generally. I mean, the starting position is that a submission agreement very much is an arbitration agreement. It ought to contain all of the necessary requirements that you ordinarily would consider. The one temptation that I would suggest we look to or challenge ourselves on when we're drafting them is not to over-engineer the submission agreement, particularly in circumstances where in most cases we've got a dispute brewing, or in fact it has already crystallised. There's been an exchange of, if not proceedings before a court, then there's a significant exchange of correspondence. The parties are reasonably clear on what the matters in issue are going to be. There's a temptation, I find, from most parties to want to then, in a very prescriptive, detailed fashion, prescribe all of the features that need to be dealt with, and forget that, of course, we have the institutional or ad hoc procedural rules that we can rely upon. There's PO1 that we should properly rely upon as well. And there's the basic principle that, of course, the more we engineer an arbitration agreement, the greater the risk that there is going to be an issue arise with it around the time of enforcement, or in fact, an inadvertent manifestation will be that it doesn't then apply to the next dispute. And we're back at square one looking to recast that submission agreement to cater for the next dispute. So I think that there certainly are, or is a history of challenges to awards emanating out of submission agreements when there have been core elements in the submission agreement that have not functioned or have been impossible or frustrated, and then have had the unintended effect, of course, of curtailing the enforcement of the award. So I think the best tip that we can give is not to over-engineer, resist the temptation to prescribe the submission agreement in too great a detail to cater just for the dispute on foot, and to rely upon the procedural rules that are relevant and PO1. In terms of template agreements, of course, ACICA has a fantastic agreement that is a great starting position as regards submission agreements on the website. So certainly as a starting point, that's where I would suggest you start.
Great, thanks. You mentioned the possibility of potentially moving cases from the courts into arbitration. Are you aware of any large cases presently before the courts that are being referred out to a process, either arbitration or a process akin to arbitration?
Absolutely. There's certainly a very, very significant case presently before the Queensland Supreme Court. The Queensland legislature recently has introduced changes to the relevant civil procedure rules up there that enable a process that for the moment is being called a referral. It is, other than by name, in all intents and purposes, akin to an arbitration process. It's not something, interestingly, that has arisen just out of the coronavirus pandemic or the COVID-19 situation that we find ourselves in at the moment, but is designed to work alongside the courts and to assist the courts in circumstances where very, very significant disputes of the type that we frequently encounter in Australia around the oil and gas sector, for example, the mining sectors, large-scale infrastructure, where estimates of hearing time can in some cases be greater than 12 months. There is an opportunity for the arbitration community to assist the courts and work alongside the courts and look at a referral process. Now, there's a number of issues that arise there, how that will sit alongside the Domestic Act, if that's the applicable Arbitration Act, the International Act, if that's the applicable Act, and just how the two will sit together, particularly in terms of challenging awards. But in most cases, I think the courts are trying to work through those via the amendments to the civil procedure rules and via detailed submissions from the parties as to how they ought to proceed. So certainly that's something that is on foot in a number of jurisdictions, as I understand it, throughout Australia, and something that ACICA is discussing with the various judiciaries.
Thanks. Maybe we'll move on now to a couple of questions to Justin, and then Joshua, I'll come back to both of you following on from that. Justin, just in terms of general powers of the courts, what power do the courts have on their own to refer the parties to arbitration with or without party consent?
Thanks, Brenda, and hello, everybody. Certainly at common law, the courts have always had a power to suspend the usual course of a trial action and refer the parties to arbitration. And to do so by consent. And I'm not talking here about abandonment of the court process, but rather within the court process, that arbitration is used as a means by which the proceedings continue, but by other means. And what one ends up with is an award or determination that comes back to the court for review and adoption, a little bit like a referee, and it would be subject to judicial review. But subject to that framework, the arbitration can proceed in the ordinary way. That's the common law position, and it's certainly embodied in the Federal Court Statute. There's a much more developed position in the state Supreme Courts, and in particular in New South Wales, where under the Civil Procedure Act and under earlier acts, there was an adoption in New South Wales since the 1980s of the Philadelphia system of arbitration that was inspired by the Pennsylvania courts, and I think the Pennsylvania courts have been running something like this since the early 18th century, that they've exercised a power to send parties out to arbitrate to see if the issue can be resolved in that way and then bring it back if it can't be. Now, the New South Wales Supreme Court's adopted that Philadelphia method. There are some limitations on arbitrability for that. That's the first problem. It's limited essentially to claims for recovery of money and equitable relief that's connected with a claim for money. You can't take fraud type claims out to that sort of arbitration. But that does cover an awful lot of cases, and a lot of the more straightforward cases in particular. The court can appoint an arbitrator. It could be a solicitor or a barrister, someone with appropriate experience. They'll be paid by the government, and there is no real scope for reviewing the award, but what there is the power to ask for a rehearing. And you might think, well, why would the parties go off to arbitration if there's the ability, if someone's unhappy, to say, well, I want to start all over again? There are a few thousand such cases in the district courts through the 90s and early 2000s, particularly in matters where you had small claims against insured defendants, motor vehicle accidents, consumer claims, smaller professional claims, where an insurer isn't interested in incurring too much costs in the way of litigation. They want to, if they can't assess the costs themselves or make a loss adjustment, they want a determination. They want to do it quickly and cheaply, and if they get that, then they will pay. And it was often the case in the district court's experience that only a reasonably small proportion of cases that were referred out to arbitration like that resulted in an application for a redetermination, at least not if the insurer lost. They were quite commercial about it. But for obvious reasons, that process is somewhat unattractive to commercial parties. Now, outside of that, there can be a power to use the powers of reference to use arbitration as a means for resolving the dispute, and you appoint the arbitrator in the nature of a referee. I should say that Philadelphia system can be done without the consent of the parties, although consent is often a relevant factor. But otherwise, the parties can at any time agree to suspend the usual procedure and go off to arbitrate, and then come back to the court to adopt the outcome.
And what is the court power that lies behind that ability, and how does it work?
If one's talking outside of the Philadelphia system, which is prescribed under the Act and the rules, one then has to fit an arbitration within the scope of a reference. And that's still going back to the common law approach, where it was in the nature of a reference to a referee. The referee tends to be quite free to set their own procedure to determine how they're going to resolve the dispute, in the same way that an arbitrator often will set their own procedure according to the nature of the dispute in front of them, but perhaps a little bit more dictatorially. Once the court sent it out to reference, or when they do, there can be agreement between the parties and perhaps directions from the court as to how it's going to be conducted, in order to ensure that it's going to be done efficiently. Once the referee comes back with an award, then it's simply a matter for the court to decide to or not to adopt it, and parties can make submissions about that. But so long as a proper procedure is followed for coming to a determination, and there's a reasonably sound award, which is what we would get in most arbitrations in any event, certainly ones conducted in our jurisdiction, the court's going to have a reasonably high degree of confidence and can adopt the decision. And if someone's dissatisfied about it, they have to use their appeal rights. So fitting within the scope of the general power of reference is there. And I think what's perhaps changed in the current environment is, with all of the problems that we're seeing in the courts having to grapple with remote hearings, and that's the superior courts. Then one has the inferior courts, the lower ranked courts, who are finding it almost impossible to conduct this. They don't have the budget, they don't have the resources, and the parties have difficulties as well. That the courts are looking to be more flexible. And if the parties come to the court, or even one party comes to the court with a suggestion that might lead to a more just, cheap and quick outcome, then the court is going to do what it can, I think, to facilitate the parties and perhaps pressure them into looking very seriously at this and trying to fashion it. I certainly have found with the judges I've been appearing for recently that they are looking, even in the superior courts, where they are trying to grapple with the current problem, that they're looking for all manner of ways to find alternative ways of resolving the issues, and looking to refer out specific aspects of the dispute which might be critical to unlocking the case between the parties, so that they then come back and deal with the residual rather than having a long drawn fight to actually get to the real issue. That's something that the courts are going to embrace if you bring it to them as a proposal. So there's a lot of scope, I think, now for the court to find whatever power it can to facilitate an alternative means of resolving these disputes that doesn't involve tying up more court time and resources.
Do you have any particular examples or cases that you've seen in practice where this would be a good candidate?
I think the first class of cases are ones where there's a particular discrete but important issue that might have a big impact on the outcome of the case. And in class actions, that's often the case because there are common issues and there might be a critical common issue that could be sent out. Justice Lee, a couple of years ago, in one matter where there was essentially a question of standing as to which of a group of plaintiffs or a foreign, an Indian consumer advocate could bring proceedings to vindicate the claim. And he had sitting in front of him conflicting opinions of retired judges of the Supreme Court of India. And he sent out by way of referral, effectively to arbitrate the issue of the conflict of evidence between the Indian experts. So determining a question of Indian law through an arbitrator who turned out to be former High Court Justice Callanan. And that matter went off on referral. It had to be determined after a few months, and it came back. And it was important to the case that it be dealt with in that way. The second, which we're grappling with the case at the moment, where no orders have yet been made. I'm involved in the case of Moore and Scenic Tours, which was recently in front of the High Court, where the court said the group members can bring a claim for distress and disappointment damages from a holiday that failed. It's very hard to aggregate those kind of damages and come to a single award of damages for the group. And what we're likely to happen is to find an efficient way for 800-900 people to bring forward their individual reasonably low value claims in a way that's highly efficient. The judge has already signalled that he expects that, subject to dealing with a couple of test examples, he will want to refer it out. And what you're almost there involved with is 700 or 800 claims that would be in the small claims division of the local court. And those are dealt with by arbitrators, where, as they're called, where there's minimal formality, often no costs, and almost zero scope for review other than on jurisdictional error. There may be a way, if it's appropriate in this case, to fashion a referral to that kind of an arbitration where there's extremely limited scope for coming back and rehearing the matter. So it's not a Philadelphia type arbitration. And if we have to, we may have to, as has been done in some cases, in Queensland's an example, look to see if something has to be raised with the Rules Committee to allow a court, especially a superior court that's dealing with a class action claim with an agglomeration of small claims, to fashion a way to send those smaller claims out to be arbitrated within the scope of the proceedings, but in a way that is highly flexible and very quick and efficient, which some form of arbitration is ideally suited to providing.
And this is really a question, Justin and Joshua. We're getting some feedback on the line, but this is what are the procedural issues around how you would craft the type of referral out and bringing the matter back into the court? What types of things would need to go into that that action? Justin, you're on mute.
There we go. Obviously, it's case specific, but if I take our example, we will probably want to have determined from the outset the basic rules of procedure as to how it's going to work, so that if there's any issue about that, that can be argued about before it goes out to the referee. In terms of when it's eventually determined and is brought back, we'd simply follow the usual reference procedure, which is to make submissions as to whether or not the report should be adopted. But that's really a question of the soundness of the way in which it's been resolved, rather than necessarily a large debate about the correctness. And in our case, where you have a somewhat a rather unstructured question of damages for a rather difficult to quantify type claim like distress and disappointment, there's not a lot of scope for legal disputes to arise. It's really a question of ensuring that a proper process is followed and a decision is made that is not extraordinary, and provided it meets the sniff test, if I can put it that way, it ought to be adopted. And a party that becomes too difficult about that is going to find itself on the wrong side of the judge very quickly, and because there can always be other measures that are used to make life difficult for them. But it's going to be because the parties, or one party, has put up a proposal that is reasonable, that accommodates the current difficulties and is likely to come to a solution that is at least fair. And the more one tries to do that, the more likely it is that judicial pressure will come to bear on the other side, if they're not completely in agreement, to come to an agreement. It's going to be a matter of taking this sometimes rather narrow door of a reference, which ordinarily has not been used to refer to arbitration, and taking advantage of the current scenario to push against what I think is an open door to fashion whatever is appropriate in the circumstances.
Thanks. Joshua, anything to add?
I completely agree with that. I think the most difficult technical issue to grapple with is around the treatment of the award itself. If it is by way of reference and the award simply comes back to be adopted in the ordinary way, and then it opens the parties up to the judicial appeal system, then that is certainly one way to deal with it. The difficulty arises if the referral in fact is going out into a regime that is very, very closely akin to arbitration with limited appeal. So that's the one technical issue, but I entirely agree with Justin. What in fact most often occurs at this process is a prolonged argument and submissions from both sides where there is a complete disagreement as to procedurally the way it is going to operate in terms of the provision of evidence, witnesses, etc. So not so much technical issues with the referral itself. It's rather the conditions on which it's going out cause the debate. Can I just offer one further comment and perhaps question back to Justin? I'm going to be very interested in the coming 6 months or so as to the judiciary's treatment of Section 7.2 of the Commonwealth Act and applications to stay, where parties aren't consenting. There is a challenge, however, an application for a stay. Whether we're going to see, in circumstances where there may well be quite a serious backlog in the courts, a real effort by either the judiciary or the judiciary and the parties to come up with conditions to enable matters that otherwise may not have given rise to the grant of a stay to in fact go out on for a stay to occur as regards the proceedings, and for them to then go out to arbitration in the traditional way, but with quite detailed conditions in order to facilitate that. I'm thinking of situations in particular where, in the traditional way, where a party has taken an unconditional step in the proceedings, which in the ordinary circumstances probably would have obviated its ability then to apply successfully for a stay, whether the judiciary now may be slightly more prone to test the parties for conditions and grant the stay. What do you think, Justin?
Yes, I think that's right. I think there's always the brute force approach, which is to say to a party that where you perhaps want them to consent to a stay, but they probably have a basis to say no, is to say, well, I understand what you're saying, but if this matter proceeds, I may be minded to refer it out to arbitration anyway. What would you like to do now? That always strikes me as the way in which some of our judges would deal with a problem like that. If you don't agree to something that's reasonable, they'll impose it on you in some other way. I think that's where one advantage I think you have in some of the jurisdictions we have in New South Wales is there is a culture that is imposed from the bench, built around expectations of how not only counsel but also solicitors and parties will conduct themselves. And in commercial causes, we know from the commercial list and other places that the court is providing a fantastic service to commercial parties in New South Wales, but they're going to expect a bit of quid pro quo, I think, at the present time, from parties to be reasonable about matters and not unduly impose on the very strained resources of the court. So the judges will be as creative as they can be if they can see that there's a fair procedure to be followed, and that parties should be encouraged to get to that answer.
Yes, that's exactly my inclination. I think particularly for those big cases that are prone to dominating in a disproportionate way the resources of the court, it's not difficult for one to envisage the judiciary being reasonably suggestive in terms of their request for submissions as to conditions that could make a stay or facilitate the granting of a stay.
We have a question from the participants that's come in to both Joshua and Justin. Really goes to something, Joshua, that you had mentioned, which is when you are actually removing a case into arbitration for final determination through arbitration, and it's partway through the process, does the arbitral tribunal need to adopt all of the prior judicial decisions and interlocutory decisions through some kind of procedural order in order to bring all of that into the arbitration? How would that work in practice?
That's a great question. There's two ways that can operate, and it's by consent, or it's indeed in then imposing upon the discussion that Justin and I have just had as regards the conditions imposed. So certainly if conditions are posed by the judiciary, then one or both of the parties will be in breach of those were they not to be followed. Alternatively, the parties can agree to adopt conditions for that referral out to arbitration, and sensibly they would simply form part of PO1. And it depends entirely upon how far along the litigation path the case has evolved. And if there has been an exchange of evidence, for example, that evidence might be adopted as evidence exchanged in the arbitration. If there has been discovery, likewise, that may be adopted. Equally, the parties might choose for one reason or another to surgically select some and not others. And again, that would either mechanically be done by consent and then adopted into PO1, or it would be by conditions delivered by the court. Sorry, Brenda, I think you might be on mute.
Justin, anything you'd like to add? Or Julia?
I agree.
I love it when we're in agreement. There was another request from the participants. If Joshua, you could perhaps send around or send to Deb to send to everyone the any publications or copies of the judgments that you were referring to from the 2000s about referrals out?
Yep. Certainly.
Sure.
It's the Commandant cases. There's a BHPB and COSCO from 2008. There was a couple in 2006 in particular, and there is a decision of Kirby in 1988, 1989 when he was still at the New South Wales bench, etc. But why don't I have a chat with Deb after this and we can circulate the details of those cases.
Excellent. Well, we're coming to the end of our session, and I thought I would give each of you the opportunity to have any last thoughts, words. Julia, you first.
Sure. I was actually just going to chime in terms of what Josh and Justin have talked about, and I think it's absolutely right that now is a really important time for some out-of-the-box thinking and flexibility in processes, and also appreciating that this may not necessarily be something that's permanent, but that facilitates getting through this backlog and the whole dimension of access to justice. And actually a colleague just brought to my attention before the seminar a really good example of this that's been put in place by the WTO. And this has sort of been relatively recent in terms of, obviously there's been a whole lot of issues with the appellate body that normally sits above that addresses those decisions. And so because that's fallen away, at least for the immediate term, what they've come up with is something called the multi-party interim appeal arbitration arrangement. And so essentially those issues are now going to go to arbitration to be determined. And it's very much the way the rules have been couched from a quick look, being done on an interim basis. But I think it's a really good example of, firstly, how arbitration can be used in these sort of circumstances, and the ability to craft it to just be something that's temporary, or obviously from arbitration practitioners' perspective, potentially more permanent if it works.
Thank you. Justin?
I think all of us involved in arbitration need to think about the product offering over the next 6 to 12 months and perhaps beyond. There is the problem I've identified. There's the opportunity from judges' attitudes to referral out to arbitration, or from the parties wanting to grapple with that opportunity. But the slightly more cumbersome institutional rules that are in place to deal with the go-to-woe type arbitration need to be adapted for something that involves just picking up cases that are almost ready for hearing or are ready for hearing, but the courts can't deal with them. And it's a bit of a plug. My floor, 7 Wentworth, has just come up with a scheme to pick up those cases where people want to have ready for hearing, and they want to have a matter set down for hearing very quickly before an arbitrator, and will commit to give an award within 2 weeks of a hearing, and do it at a capped fee. That's designed to give something back to the system that's been doing a lot for us for years. And there are no complexity of the rules of procedure. We'll adopt the pleadings, the evidence that's already been put on, and deal with the problems at hearing. It's a little bit like a very old-fashioned trial in that sense, and deliver a decision very quickly. That replicates the best of what the commercial list can offer parties when they're being speedy. And I'm sure others will come up with similar ideas. I think we have to go out to our clients and sell the highly flexible aspects of arbitration and the ability to fashion something that is fit for the immediate and idiosyncratic purpose of the case. Not be too worried about the perception of arbitration as some sort of big ticket litigation between well-resourced parties dealing with something that people are unfamiliar with. We have to show that, I think, to our clients out there that there's a way of presenting this as an actually very simple, quick solution to the problems that they're facing because of the burdens that are on the court system.
And I think the ACICA submission agreements that are on the website, one of them is specifically targeted toward that, which adopts the ACICA expedited rules and a streamlined procedure, and the possibility of parties to choose whether they have a hearing, not have a hearing, how long the hearing might be, those types of things, along with a reduced registration fee for the next few months. Joshua, last thoughts?
One very quick philosophical question, and then perhaps a couple of teasers to leave us with. And the philosophical one is to adopt everything Julia and Justin have just said, and just to challenge all of the arbitration practitioners. I think this is an excellent time for us not to go to market to really aggressively promote arbitration in place of litigation, but for us to work alongside the court to assist them. And I think it's a nuanced but subtle difference. I don't think we're doing our colleagues as litigators any favours by really aggressively going to market and saying, now's the time for arbitration to shine and we all ought to forget the courts. So I think it's a very subtle difference, but it's a great opportunity for us to be advancing all of the opportunities that Julia and Justin have just described. The two teasers, investor state and trade agreement related arbitrations, BIT arbitrations, etc. Watch this space. I think that there's likely to be a significant uptick over the next couple of years, notwithstanding what the Columbia Centre for Sustainable Investment said just overnight. And the second one is to go right back to what Julia said. And I will be very interested to see whether the debate around antitrust or competition-related arbitration reignites. I was fascinated with what Julia said about that. And I do wonder whether, as more and more corporates are looking to collaborate, etc., and to prove the difference between cooperation and collaboration and cartels, etc., as to whether there is going to be increased activity in the antitrust space and whether that gives rise to an opportunity to test antitrust-related arbitrations, and also whether it might be something that other regulators in the space, such as FIRB, where we now have extraordinary amendments to the FIRB requirements in Australia that are likely to, and indeed are creating significant delays and backlogs in that particular space, whether that could ever be something that we fit into the bucket of arbitration. We'll see.
Well, thank you all very much. Justin, do you want to say something?
Well, I think just one thing final, I think pulls together all that we've said. Matters that often have been considered to be not arbitrable, or which there's a lot of resistance to allowing them to go to arbitration, suddenly can become arbitrable if they're done by referral out from courts. Because on a court referral, arbitration is just another way of resolving the matter before the court. It may well be that because it remains before the court and comes back to the court, that matters that, like antitrust, etc., that might previously have been considered non-arbitrable, particularly some of the more sensitive areas, become arbitrable because it's still within the court system. And that flexibility of thinking around using the court procedure and the arbitration system, as Joshua put it, in a complementary and cooperative way, can break down some of the traditional barriers that we've found between arbitration and litigation in the remaining areas where there's no scope to just go off to arbitration.
Thank you all very much. We have come to the end of our time. There are a couple of audience questions that we did not get to, but we, for those of you in the audience whose questions we have not addressed, one of which is a whole topic of a seminar of its own, we have further webinars coming up, and we'll work those into further presentations. So if we were in a room, you would all be hearing claps, but just a virtual thank you to all of our panelists, and thank you to all the participants for listening to this kickoff webinar. And we'll see you at the next event. Thank you.
Thank you.
Thanks.
Thanks, Brenda.